Hi, welcome to Constitutional Chats, hosted by me, Janine Turner,
and Cathy Gillespie,
with students
Cathy Chapman
and me, Tova Kaplan.
Join us as we discuss hot topic issues with constitutional experts. It's sponsored by Constituting America.
Welcome to Constitutional Chats. We are so excited that you're with us today. I'm Cathy Gillespie. I'm the co-chair of Constituting America. And I'd like to introduce some of our panelists, and then we'll get to our special guest who we're very excited about. We are talking about the Fifth Amendment today in our series, The Bill of Rights and You. Thank you to everyone who is with us today. We wish you all a very happy Thanksgiving. And we want to thank especially our sponsors, Mr. Kerry Hobbs and his daughter, Cindy Janeka of Waco, Texas. Janine and I went by and saw Mr. Hobbs a few years ago at his office, and Cindy, and they are just great Americans and patriots. And thank you both for sponsoring our constitutional chat today. Now, joining us soon is going to be our founder and co-president, the actress Janine Turner. Janine is famous for her role as Maggie O'Connell in television's Northern Exposure. She's founder and co-president of Constituting America, which launched in 2010. And she's still acting, but she's also actively teaching kids about the U.S. Constitution, having given over 600 speeches to classrooms across the country. And Janine is just a wonderful leader of our organization and adds so much every day. It's one of my great pleasures to get to work with Janine every day on promoting the Constitution to students.
Hi, everyone. Welcome.
We also have with us today Tova Kaplan. Tova is a 16-year-old student from Chicago, Illinois. She's a 3-time winner of our We the Future contest, is the National Youth Director of Constituting America, and runs the Youth Advisory Board. Tova is passionate about inspiring young people to know and use their constitutional rights. And Tova, I'm going to kick it over to you and let you say hello to everyone.
Great. Thank you so much for that introduction. And this is my last time I get to be announced as 16. I'm finally turning 17 this week.
And I might mention that we are unfortunately missing Dakari Chapman. Dakari is usually on with us as one of our panelists. Dakari is an 18-year-old student from North Carolina. He's Constituting America Student Ambassador, serves on our Youth Advisory Board, and is a 2-time winner of Constituting America's We the Future contest. Dakari is a working actor and will be seen in season 2 of Netflix hit series Outer Banks, and we will look forward to Dakari joining us back next week. So now I'd like to go ahead and introduce our very special guest, Mr. J. Eric Wise. Mr. Wise is a partner in the New York office of Gibson, Dunn and Crutcher, and is a member of the firm's business restructuring and reorganization and global finances practice groups. Mr. Wise is a thought leader on finance-related and general interest topics, represents financial institutions and corporate borrowers in complex restructuring and lending transactions, and is the author of numerous articles in the finance and restructuring fields. Most importantly, Mr. Wise is a longtime friend of Constituting America and has written on many subjects in our 90-day studies, including the Fifth Amendment, and participated in our New York winter mentor trip, dining with our student contest winners as our guest constitutional scholar. So I'd like to turn it over to you, Mr. Wise.
It's really great to be here. I really appreciate the opportunity to talk about the Fifth Amendment with such an august group of many ages. Fifth Amendment is a very interesting topic, and I think we'll have a lot to talk about over the next hour. I want to start with the way the Constitution was designed. It originally did not have a Bill of Rights, and that was by intention. It had been suggested over the Constitution and the ratification debate leading up to its ratification that one of its defects was that it did not have a Bill of Rights. And in the Federalist Papers, Hamilton argued that it didn't need one because of the change in the structure of the government from a kingship, essentially. So in a kingship, the king is a sovereign and he holds all of the power. over his subjects. And so the idea was that a Bill of Rights was necessary because that cut back on his unlimited power and restrained him from doing something. Under a republic, which was the United States, it's its conception and still is, the idea was that the people hold the power and they delegate that power to the state and national government. The case made for a Bill of Rights in the ratification debate was so strong by the Anti-Federalists. Shortly after the adoption of the Constitution, James Madison started to assemble a series of amendments that would become the Bill of Rights, which would be included in the Constitution. All 10 of them were done at once, rather than, for example, one passed and then the other and the other. So they were really part of a package. And so the number 10 was actually considered when they were putting together the Bill of Rights. And I don't want to suggest too much about this, but it's a number that had some persuasive force because it's also the same number of commandments in the Old Testament. So let me just read the Fifth Amendment. So it says, it's got several parts. So some of these are not directly related to one another, so I'll pause appropriately. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. And that's the whole of the Fifth Amendment. And we'll get to the various parts. Where I left off, I think I was just discussing its place in the 10 amendments. So, and comparing it to the 10 commandments, which has 2 tablets, and they're connected by the injunction to honor one's mother and father, which is a person-to-person relationship or a relationship between people and establishes an order in a household. And it also is a microcosm of the injunctions to have no God before God. So it's an interesting thing that they chose it that way, and it also suggests that the Fifth Amendment and being its central in that list is fairly important. So the Bill of Rights is also organized into 2 fundamental sets of rights, which are, so the first rights are, and I'm just going to quickly do this because I know we're here to talk about the Fifth Amendment, are free press, assembly, and conscience, right? The rights with respect to religion, establishment, and free exercise. The right to bear arms and no quartering of soldiers, and the right to search and seizure. And those are amendments 1 through 4, and they sort of create an environment for a republic where the government is not intrusive, right? Which allows you to engage in deliberation and doesn't have control over the people. And then the second half of the Bill of Rights, 8 through 10, deal with limitations on punishments. So they restrict bail. Bail, when it's set excessively high, allows you to punish someone without convicting them of a crime. And the rest of the amendments then deal with the retention of rights of the people and the states. So the Fifth Amendment, 5 through 7, really deal with these procedural issues. So returning the first issue in the Fifth Amendment, there's the right to a grand jury indictment. Okay, so in capital offenses or otherwise infamous crimes, this was meant to mean a crime where the federal government was prosecuting someone for something of a serious nature. And the idea was that of the national government from prosecuting someone arbitrarily. So before they could prosecute you, they first have to indict you, which is to say, which is a formal way of saying I accuse you of something. And in order to do that, the Fifth Amendment required that the federal government go to a grand jury and present facts to a grand jury. And it was supposed to be a jury of people drawn from the community who would know something about the facts of the case and know something about the people. And then they would decide whether or not to accuse, so that the government alone didn't have the power to accuse someone of a crime. And that's what the clause with respect to grand jury indictment is. Now, there's room to discuss what is an infamous crime, right? Because the words that they used at the time may not be as clear to us today as they were to them then, but it's meant to be a serious crime. The next is the right against double jeopardy, right? So if your government is trying to use the criminal law, which is an important part of any society, right? It's important that the government be able to prosecute crime, but to use it as a political tool, and so right against the government brings bills to they keep trying to get a conviction. An important protection. It's government's power. And then the next one is the right against self-incrimination, which says that you've all heard that so-and-so maybe pled the fifth. And the plead the fifth means that you decline to make a statement about something that could be used against you. And you've also probably seen on television, when someone's arrested, they read them what are called their Miranda rights, which says you have the right to remain silent, and anything you say can and will be used against you in a court of law. That comes from the Fifth Amendment, and that's about the concept of justice was that the parties prosecuting a crime could not build the case on a person's own statements, because what it does, if you can build a case on a person's own statement, it invites prosecutors and law enforcement to try and coerce a confession from somebody. It's the easiest way to convict somebody of a crime, to try and force them to speak on a subject and then take their words out of context, or to compel them to sign a confession and then use it against them. So the right against self-incrimination is very important, and it's important in our system. It's often misunderstood as well, because often you'll see in the press or the media, someone says they've taken the Fifth Amendment. And that's often cast as though there's an inference from that they've committed a crime. Now, you're actually under the Constitution not permitted as a prosecutor to raise the fact that someone took the Fifth in order to make an inference that they were guilty. And that's a very important thing, because everyone is presumed innocent. And if you're not supposed to build a case against somebody on their words, but on the words of other witnesses and other evidence, then you're not supposed to, when you hear someone took the Fifth, say, well, that person's probably a bad person because they took the Fifth. In my view, the right way to think about it is that person's just like any other person, and there should be no negative inference from the fact that they did not want to cooperate with a prosecutor, because the prosecutor has to make his case, or the law enforcement, from something other than their own statements in accordance with the Constitution, and really the rights that go all the way back to the Magna Carta, where these rights were first forced onto King John in 1215. The next is the right to due process with respect to deprivation of life, liberty, and property, which is very important. And it actually has all kinds of everyday effects. There are process clauses. I mean, there's one in every state constitution, I think. I don't know if there's one that doesn't have one. But regardless, the 14th Amendment has a due process clause that applies to all of the states as well. And the Fifth Amendment says, with respect to the federal government, you have to be entitled to due process. And then the final clause, and I'll pause after that, I know I've taken a little bit of time, is the right to compensation for property if it's taken for public use. So if you're building a highway, the government has the power to say, I'm going to build the road through your neighborhood. And in doing that, they can say, well, I'm going to take that land, your house, your yard, and I'm going to build the road through there. And that's sort of an important function of government, because there are times when the use of land or property for public use is needed. But the rule that under the old English Constitution, the king could just do that and not pay you for it. I think it was included in the Magna Carta that he had to pay them because he used to use it as a tool of abuse, right? I don't like the way you're behaving in my monarchy, so what am I going to do? I'm going to put a highway right through your home, and I'm not going to pay you for it. So the Fifth Amendment says that you have to be paid, and you go to court and they try and figure out what a fair market value is, and then you get compensation for it. And the last point I'll make about that is there's some fighting that goes on as to what's a public use. So in modern times, municipalities have come up with schemes where in order to engage in an urban renewal project, they will condemn property and then transfer it to a private mall builder, for example. And the mall is supposed to make the downtown area better and at a public use if you condemn it and then sell it to a developer.
Thank you. That was a great overview of the Fifth Amendment. And, you know, when I think of the Fifth Amendment, I always just mainly think of pleading the Fifth. And you just pointed out there's so much more to it. And you did a great job going through all the different sections. I'm going to toss it over to Janine to kind of start our discussion. And I could see Janine furiously making notes. So I know that you have got a lot to say about it. So Janine, tell us some of the things you were writing down during Eric's talk.
Okay. Hi, Mr. Wise. Okay.
Hello.
Thank you so much
Nice to see you.
for that intro. It was very, I learned quite a bit. So I just want to unpack it for our younger listeners and also ask a few things, and then I'll toss it back to everybody else. I thought it was really interesting what you said. First of all, I'm not sure our younger listeners will understand what a capital offense means, and I'm not sure they will exactly know what a grand jury is. So I think it'll be good to break those two things down. But before we get to that, I never realized that when you're accused of a crime, you have the right to let's say the government accuses you of a crime. You have a right to not really be accused of that crime until the grand jury accuses you of that crime. And so what you said here is because the government, it's a step away from the government. The government can't come in and accuse you of a crime. The people do. I think that's really interesting. I have never, ever, ever, ever seen it that way. The other thing that I thought was interesting that he said, I always think about the Fifth along the lines of what Mr. Wise was talking about, that the Fifth Amendment is like, I plead the Fifth, that you're really guilty, you just don't want to talk. But I guess what that's saying to us, if you're arrested and they want you to talk, we all know the Miranda rights, but the Miranda rights really come from the Fifth Amendment. I'm assuming that if let's say you're in your car and you're pulled over and you're arrested, they have to read you the Miranda rights, but you don't have to speak at all. You don't have to say anything.
Correct.
Because you law shows where they come in and they try to intimidate you and they try to talk to you and they talk for a little bit and they finally said, I want my lawyer. But you don't have to say anything to anybody, do you? You just get a lawyer and you don't have to say anything to anybody. So I'm going to toss that back to you about that, because I think that's really interesting, but also about grand jury capital offenses and how the government's the only ones that can really accuse you of a capital crime. Now, and you might want to break down the difference between a capital crime and where a government can accuse you of something without a grand jury.
So you would raise the issue of what's a capital crime and what's the first clause, the meaning of the first clause. So the threat that's perceived from the state is that the state would bring a crime against somebody that's motivated politically, meaning they want to punish a political opponent. And so as a stumbling block to doing that for major crimes, and they're listed in the amendment as capital and infamous. And capital means, comes from the word capita, which is Latin for head, because it's off with your head. It's essentially the death penalty or life imprisonment. And an infamous crime would mean basically probably anything that's a major felony. The felony is more than 1 year imprisonment. So those are the sorts of crimes. So for a minor crime, they don't have to go to a grand jury. You can have a pretrial hearing for an indictment, but for any major crime, they need to go to a grand jury. So what's a grand jury? The grand jury is a panel of citizens like a jury in a trial, except for it's assembled for the purposes of determining whether or not to make an indictment. So you assemble, it could be 12 or 15 people. It's usually not 12. It's usually a little larger for a grand jury. So your grand jury pool sits there and the prosecutors come and they present the evidence, which is to establish probable cause, charge the person with a crime. So present the entire case, they'll present bits and pieces. The grand jury, the one who ultimately has to make a decision to indict. And while I mentioned the stumbling block from for a political prosecution, it's not a huge one, because often the grand doesn't know that much about what's going on, and there's nobody in front of the grand jury representing the defendant who has the opportunity to show, well, they have an alibi, they weren't there, and so they couldn't have committed the crime, because that's reserved for the trial. So at the grand jury, the prosecutors will say, there was a crime committed and here's how it was carried out, and we think there's probable cause to believe this person committed the crime, and so forth. and then the grand jury decides, and the grand jury has the power. And you
Wait, wait.
mentioned it.
But Mr. Weiss, there's no defense attorney in front of a grand jury?
No, the prosecutor simply goes to the grand jury and presents its case, and then the grand jury indicts. Is in front of the grand
Wow.
jury. Right.
That
to their
doesn't seem
counsel.
fair.
Well,
That doesn't, I mean, I know I'm not a lawyer, so I'm going to sound very naive with all this, but I'm always the one that's willing to like sound stupid for the sake of the rest of us that are thinking the same thing. But I don't think that that's fair.
Grand jury,
that seems odd.
Grand juries are conducted in secret, so the defendant doesn't really know what's going on. Part of that grand jury secrecy is to protect the potential defendant's reputation. Because the jury refuses to indict, nobody is supposed to know what went on in the grand jury room.
Yeah, but the fact that he can't be, that there's no defense attorney to say, well, that's interesting. Okay, so now we know, are there 12 people on a grand jury?
No, not necessarily. It can be larger. I don't know what a federal jury, never the federal grand jury, but maybe 15 is the number. But it's a large number of people. Now, each state, for example, if you go state by state, some of them have a requirement for grand jury indictments as well for their prosecutions. And so they'll have different size dependent on state law for that.
Well, I was just going to note that that Professor Klinger is on, and Professor Klinger noted that most criminal cases involve state offenses. 2 states do not have grand jury indictments, since this is one provision that has not been incorporated by the Due Process Clause. I was just going to read what Professor Klinger wrote. And then Professor Klinger elaborated and said the Bill of Rights was applicable to the federal government. The 14th Amendment Due Process Clause has been continued to apply Bill of Rights standards to state governments. Of course, most state constitutions include many of the same rights that are in the federal Bill of Rights. And then he also said that Connecticut and Pennsylvania do use grand juries in criminal investigations. So I guess the question is, are there some states that maybe don't use grand juries in state investigations, or?
Yes. So I don't know the number of states, but he's absolutely right. So there are 2 due process clauses, one in the 14th Amendment, which applies to the states, and the one that is in the 5th Amendment that we're talking about only applies to the federal government. When the Constitution was originally conceived before the Reconstruction Amendments, the 13th and 14th and 15th Amendment after the Civil War, there was no real restriction on what the states could do. And there's a concept called substantive due process, where courts have said that the due process clause has a broader meaning, and you interpret it by saying that the Bill of Rights applies to the states. When it was originally conceived, the Bill of Rights only restricted the federal government from its behavior. So the state governments had their own bills of rights, and they could do things that violated the first 10 amendments, because they really only restrict the federal government. And it was part of the federal construct. And it wasn't until after the passage of the 14th Amendment, the second due process clause, where you start to talk about substantive due process. But in states, and I'll give you a personal example. When I graduated from college, I was a reporter in a small county in Michigan, and I used to cover criminal trials in schools. And there was a young man who was accused of a crime, and he was being interviewed by the police, and they asked him, he asked to see an attorney and said he really didn't want to talk about it, which is a way of asserting your right to remain silent. He was a teenage kid. And the police said, you don't need an attorney. What you really need is to get it off your chest, which was a violation of his 14th Amendment right to remain silent, which is an incorporation of the Bill of Rights. So that was one thing. And then the second thing is when he was indicted, they did it in a pretrial hearing rather than with a grand jury. So he was brought before the court.
Who is they? Who is they? I'm sorry, I don't know who we're talking about.
The state prosecutors in that case.
What state? What
state of Michigan.
Okay. Mm-hmm.
So in the state of Michigan, he did not have a grand jury indictment. He had a pretrial hearing in which they determined to charge him with a crime. The police and the prosecutors had already determined that they wanted to charge him, but they needed permission from a court as part of the indictment process. So that's an example where the state was acting to bring a criminal case without a grand jury.
Okay, why?
I think
Do they not abide by was that a federal crime or was that a state
it was
crime?
a state crime. It was a state crime, and
okay, and what are the two states that don't abide by the, Mr. Klinger could tell us, Cathy, if you know, Mr. Wise, I'm sure you know too, but what are the two states? I'd like to know if I'm living in a state that doesn't abide by
Pennsylvania and Connecticut.
But why did Michigan get away with doing that then? Not letting him have a grand jury.
So real quickly, so with the state and the federal government, the federal system, there are two governments. One is the state, and they have purview over most criminal law. There's also the federal government, and there are some federal crimes. Typically, when you commit a crime, say you've stolen a car, that would be a state crime. If you take it across state lines, that might make it a federal crime, and then you could have a prosecution for a federal crime. So the double jeopardy clause says that in the Fifth Amendment says that the federal government cannot try a person twice for the same crime, which means they can't charge you with bringing a stolen car across state lines, fail to get a conviction, and then bring the same crime or a very similar crime, like a lesser included offense, against you in order to keep bringing an action against you. However, they could appeal, but it's very rare to have a appeal by the prosecution if you don't get a conviction. There is such a thing as a mistrial, where you have an error in the conduct of the trial, and that's not considered that you've ever been fully tried. So say there is a problem in the way the trial is conducted, and that's declared a mistrial, then the federal government does have the opportunity to bring the trial again, though typically for reasons of appearance, they don't do that once they fail to get a conviction. But if they get all the way to a jury and the jury acquits, they cannot bring the crime, the charges against you a second time with another jury, right, to try and convict you. However, there is a situation where you have a crime that's committed at the state level. And a famous example of this was the Rodney King trial, where the police beat Rodney King. And an action was brought against the police officers under California law. And they failed to get a conviction of those police officers, which led to the LA riot in 1991, when people were disappointed with the Bush administration instructed the Department of Justice to bring a civil rights action against the officers afterwards. So that was a federal crime that he brought. And many people said, well, wait a minute, isn't that double jeopardy? Technically, under the law, that's not double jeopardy because they were tried for different crimes. One was the state one and one was the federal one. But there were a lot of complaints because culturally, we all come to accept that's not appropriate. Then
just to go back, it seems to me if someone's accused of murder and the jury declares them not guilty, that person not guilty, he wouldn't want to appeal anyway. But if a person is accused of murder and he is considered guilty, he can appeal, right?
That's correct.
So the double jeopardy really applies to the prosecutors. You cannot prosecute the same case twice if you lose.
Right. The defendant can appeal, exactly, and he can appeal all the way to the Supreme Court on issues with respect to process, whether there was appropriate evidence, whether evidence that should have been excluded was excluded. For example, there's a concept which I'll just mention under the Fifth Amendment, particularly with respect to the right of incrimination, but it also extends to other things like search and seizure. But for example, if the police force a confession from somebody, and that leads to other information, basically violating their right not to bear witness against themselves, to not incriminate themselves. So forcing them to make statements. And that leads to other evidence that they bring in, which they use to get a conviction. On appeal, there's a concept called the fruit of the poisonous tree, which is everything you get from the violation of the person's civil rights under the Fifth Amendment is then excluded from the evidence and can't be presented against you in court. Which is in order
Okay,
to.
I want to go to Tova, because Tova's got to sign off. I want to make sure she can ask some questions. Sorry, Mister. Go ahead, Tova.
I don't really know much about this amendment, to be honest. I wish we were taught more about it in school, but I just think it's really amazing that the Constitution and the Bill of Rights just gives so much respect to people, that we're willing to make provisions for people's rights, even when it's inconvenient. Like, I can imagine it would just be so much simpler for law enforcement if they could just, or for the government, if they could just let people indict themselves. You know, it would be much faster, easier. But the Constitution holds people's personal liberties in such a high regard that they're willing to not let people have these rights, affirm the inherent rights that people have, even when it's inconvenient, even when some people who have committed crimes might not even be convicted at all because of their rights. We're willing to make those exceptions because just people's rights are so inherently important. And I think it's amazing that, you know, laws that were developed so many years ago are still in full force today, that we're still abiding by the same rights that were spelled out in a document that's hundreds of years old, and they still apply. You know, law enforcement still abides by them today. Our court system still abides by them today. And I think that's a really amazing thing about our country. I was wondering why there's a provision for military, like in the military, or in times of war, why that's an exception to the law?
Right. So with respect to the grand jury indictment, and the reason for that is to make a court martial more efficient. So a state of war is considered a condition of emergency, and in order for the standards for justice within the military are lower because of the urgency of the nature of conflict and the danger involved in not being able to prosecute the conflict. So the sad truth of it is that in the military, if you're charged with a crime in a war, you're not entitled to a grand jury indictment, even if it's a capital crime.
And what's to prevent, for example, like the president declaring a state of emergency or a state of war, just so that they could bypass constitutional rights? Is there any protection against that?
Well, there is in the Constitution, which is that only Congress has the power to declare war. So in theory, the United States has not been at war since the Second World War. We all know that in practice, that's not true. It's an unfortunate deterioration of that constitutional rule that Congress no longer really declares war. However, they do have done in the past authorizing resolutions, which are functionally the equivalent of a declaration of war, but they've moved away from calling them that formally. What's to stop them is that they need Congress in order to do it, and the president on his own doesn't have power to declare a state of emergency, except to the extent that it's already embedded in a law that was passed by Congress.
Great, thank you so much. And I was wondering, how has the interpretation of this amendment changed over time, over the course of American history, especially as we've had a lot of technological advancements or just changes in the way we view these laws? How has that been shaped?
Sure. So I think the biggest change has been with respect to the concept of due process. And due process, when it was originally conceived, was largely procedural. For example, things like if you're going to take an action through the courts, you have to give notice to the affected parties, give them a letter that says we're going to hold a hearing on such and such a date. and then have a hearing where they can say, well, wait a minute, I object to that. That's not right. It affects my rights, or you have the facts wrong, right? So that's the basic provision of notice and a hearing for a government taking an action. So that was a procedural protection. The due process over time, people, as they were looking at it and courts were looking at it, they said, well, does it have a substantive component? And when they meant substantive component, does it have specific rights that are implied in due process, meaning that if you don't protect these rights, then you don't have due process, regardless of the process you're using. So the most famous one of that is the right to privacy, which was established in Griswold versus Connecticut. In that, the court said that when you look at, and this was related to the 14th Amendment, but it doesn't, it's the development of the concept of due process. The court said, when you look at the Bill of Rights, there are all these intersecting concepts in the Bill of Rights. And they specifically said that there are penumbras and emanations, which were words that nobody knows today and nobody really used then. I'm not sure why they did it that way, but they said basically to say there's like this shadow that comes from the Bill of Rights, which tells you that there are other rights. And one of those is the basic right to privacy. And that is part of due process now under the Constitution. So that was the major change. There were, before the, many people think that the concept of substantive due process really started even before that, which was in these cases called the Lochner cases, where the in a court case they determined that the states could not establish certain labor laws because it violated the rights of labor to enter into a contract. And they said, well, the freedom to contract is just a basic right associated with ordered liberty. And so no state can make a law that restricts the ability of a worker to enter into a contract, like something like a minimum wage law. Those cases were struck down, but many people point to those as the origin of the concept of substantive due process.
That's so fascinating. Thank you. And I remember kind of before we went live, we were chatting a little bit, and you mentioned that it's kind of interesting that this provision wasn't included in the actual Constitution, but was later added with the Bill of Rights. So could you elaborate more on why that was?
Sure. So the structure that the Americans were leaving was that of a kingship. And in a kingship, all sovereignty resides in the king, right? He has absolute power over the government, and its source of authority is his person. So in the Republic and under the Declaration of Independence, it's sort of reversed. So the citizens of the country are sovereign. The people of the country are sovereign, and they delegate that power as a body to the government. So they create the state governments. So the people of a state create the state government. They delegate their sovereignty to it. And they also create the national government. So when they were designing the Constitution, they thought, well, the people are sovereign, and so they're sort of the king. And so they don't need to create a Bill of Rights, because a Bill of Rights, they thought, was something that if you had an all-powerful king, then you would chip away at his power with a Bill of Rights. So they figured that the government was limited. They hadn't given the national government more power than they wanted to. They enumerated all the things that Congress could do in a list. And then they added one clause and said they can do everything else necessary and proper. And so they felt the Bill of Rights wasn't necessary. When they were ratifying the Constitution, there were two groups of people who argued for and against the Constitution. One were the Federalists, who were led by Hamilton and Madison, who wrote the Federalist Papers together, along with John Jay, another famous founder. And then the Anti-Federalists opposed them and opposed the Constitution. They wrote essays which were loosely grouped under the name Anti-Federalists. And one of their most powerful arguments was that the Constitution lacked a Bill of Rights. And Hamilton argued against it, saying it wasn't necessary for the reason that I gave, that the national government only had the power that was given to it. But that argument was the most compelling one in the argument over ratification. And so as soon as the Constitution was ratified, James Madison began collecting rights, which were mostly found already in the various state constitutions, and assembled them into a Bill of Rights.
Yeah, no, thank you, Eric. I actually served on a grand jury, and I, like Janine, was really surprised that there was no defense lawyer in the room. We had a prosecutor who laid out the case for the different charges, and sometimes they would bring a police officer in to elaborate on some of the cases. I feel like I'm a fairly informed citizen, so I do think it's great that we spent some time today talking about grand juries and the way that they work. We do have a listener that has a question about pleading the fifth. Deanna Charist asks, once you plead the fifth, can you change your mind? And if so, how many times can you change your mind?
Well, you can't change your mind with respect to something you've already said, which is why the Miranda rights that they read to somebody who's arrested are you have a right to remain silent. So if you say something incriminating in the process of your arrest, then it's hard to put the cat back in the bag. But you can assert your right to remain silent at any point in any proceeding. However, there is a rule that if you can't selectively use the Fifth Amendment. So if you're going to take the Fifth Amendment on a subject, the general rule is you have to remain silent on everything. And you can't, for example, say, well, I want to talk about this, and I want to say this that undermines the prosecution's case, but I'm not going to have to answer any questions. To prevent, for example, someone who's accused from cherry picking information and not telling the whole truth about it. They have the right to remain silent as a result. But however, if you, for example, were interviewed by, say, the FBI, and halfway through the interview, you decided, maybe this isn't a good idea. I'm not sure that they have my best interests in mind, and I think I'm a suspect, and I'm worried that something I say will be used against you. You can stop at any point and say, I'm not going to give any further testimony, and they don't have any power to make you continue talking. They may invite you to continue talking, which is often comes up in these Fifth Amendment cases where the police say, or the investigators say, well, you really should just talk about it. If you haven't done anything wrong, it's better that you talk about it. That's a tactic that you see on television, but that's.
Well, and I had another question regarding the Fifth Amendment. A lot of times in congressional investigations, we see people plead the Fifth Amendment. I think I remember Ken Lay pled the Fifth Amendment, for instance. And here it seems like it applies more to criminal cases. Is a congressional investigation a criminal case, or how does someone plead a Fifth Amendment in a congressional investigation?
There are basically no contexts where you're not entitled to not speak, because you are concerned that what you say may be used to convict you of a crime. So whether you're being investigated, whether you're a suspect or not, you have the absolute right not to speak, and it cannot be used as an inference of your guilt against you. There's no context where you're obliged to speak if you think that your speaking could result in it being used against you in a criminal trial. And you can take the Fifth in any context. Obviously, it's usually in a governmental context. What happens in these congressional hearings where there's a particularly intense political motive, for example, it happened in the Solyndra case, where executives took the Fifth Amendment before Congress, not because they'd committed a crime, but because when you know that the big political interest in the national government or the state government, whatever the body is, but the national government are focused on this, on you, the advice from counsel will often be, you should just not speak on the subject because there are very strong motivations to prosecute somebody for what's happened. And you may be better off just not saying anything.
Okay, well, great. And to wrap up, we still have a few people who are confused on due process. And Professor Klinger had said the concept of due process is a bit slippery. Normally, it would mean the government must allow those against whom an action is taken, like a citizen, to have a chance to defend themselves before an impartial arbiter. Due process is a standard applicable in criminal proceedings, but also in civil and administrative cases. The amount of process that is due depends on several factors, including the seriousness of the action taken against a person and the chance for irreversible error. So, Eric, could you unpack that a little bit?
So due process ranges, he's absolutely right. It ranges from very minor things all the way up to you need a trial in front of an impartial jury and basic concepts of what they call ordered liberty that have to be respected when there's your life or liberty is at stake. To give you the smallest example is that if you are driving down the street and there's no speed limit posted, and you think that it should be 30 miles an hour because of a reasonable inference, and you're pulled over and you're told that it's a 15-mile-an-hour zone, it would be a due process defense that there was no notice of the speed limit. So another case would be, for example, if the regulator were to impose a regulation, but were to fail to go through the process of publishing that regulation, and so you violate the regulation. Maybe you don't package something the way you're supposed to, but you might challenge the regulation on the grounds that it violated your due process, that they didn't use the regular channel to promulgate the regulation, so you didn't know how to comply, and so you were deprived of due process. Another example, kind of moving up the scale, would be what I do in bankruptcy court. So whenever we have an interest that's affected in bankruptcy court, you have to give notice and then have a hearing. And so the people who are affected by the decisions the court's going to make in the bankruptcy court have to receive notice, either through publication in a newspaper, or they're directly mailed notice, or they get an electronic notice, and you may be asked to demonstrate that by the court. And then they have to have enough time to prepare, unless it's an emergency hearing. And then if it's an emergency hearing, they can only do limited things, but you have to give notice so that people can appear, and then they have the right, if they're an interest holder, they have standing. If they could be harmed, they have the right to stand up and say, Your Honor, this affects my rights and it's not right for X, Y, and Z reason. Either it violates the statute or it violates my property rights or some other basis, and the judge has to listen to them. So you'll find actually sometimes in these cases that affect a large number of people, they'll even have a phone call with a phone line open for smaller interest holders to call in, because as a due process requirement for handling a matter in the bankruptcy case, they have to give everyone the opportunity to be heard.
Okay, so due process, and later, I guess, when we talk about the 14th Amendment, we'll understand why the 14th Amendment deals with due process more than the 5th Amendment, because I think I heard that today and I don't really understand that. But can you answer that in 10 seconds?
In 10 seconds, because the 14th Amendment applies to the states, and that's where you get a lot of the, that's what incorporated the Bill of Rights against the states. So the states have to comply with the Bill of Rights because of the due process clause in the 14th Amendment, which makes it very—
Unless you're Pennsylvania or Connecticut.
No, in Connecticut and Pennsylvania, it's true, but it's selective incorporation, so not all of the Bill of Rights applies. Why that is, there's not a great explanation.
That's confusing. Okay, but I love giving Pennsylvania and Connecticut a hard time that they just don't abide by the 5th Amendment. I'm not gonna let that go. Last question, General Flynn.
Yep.
That's what I would think would be a federal crime, a capital. They're accusing him of lying to the FBI, a capital offense, I would think. Okay. I don't know if there was a grand jury with him or whatever, but my lightning round question is it kept getting appealed and appealed and pushed and pushed and pushed. They just won't let it end. And even the attorney general said stop, and they're still not letting it stop. So my question about General Flynn is, at there has been a point where they have finally declared him innocent, where they're saying that the attorney general has said stop, let him go, and the judge is still hanging on to it. Is that not a double jeopardy?
It's a mess of a different sort. What happened is that
What of a different sort?
a mess. It's quite a miscarriage. But what happened was General Flynn was interviewed, not realizing he was a target. That was probably, in my view, a violation of his Fifth Amendment rights. I'm not sure that the courts found that, but in fact, I know they didn't. What he ultimately decided to do was to plead guilty to a crime of lying to the FBI. When, of course, he had the opportunity, if he'd known he was being investigated, he might have said nothing under the Fifth Amendment. But so once he pled guilty, you basically tell the judge that you've committed the crime. And then the Department of Justice under Barr chose to withdraw he tried to withdraw his plea and said, I want to reverse what I said. I want to
But
take
after many steps, this had gone on for a year.
Yeah,
That wasn't
gone on
the
for
next.
a long time. And he had not been sentenced yet. And then he said, he hired new counsel, Sidney Powell, and said, I want to withdraw my plea. And normally, the Department of Justice said, I'm not going to challenge your withdrawal. And the way our system works, you've got to have two sides fighting with each other. So if the DOJ withdraws, normally that means it's over. Judge Sullivan in that case did not want the DOJ to withdraw. And so he refused to accept the DOJ's withdrawal in a very strange move, and appointed an advocate to argue on behalf of the Department of Justice in order to prevent Michael Flynn's guilty plea from being overturned.
Well, is that not double jeopardy then?
It's not double jeopardy because, one, he was never tried for the crime. He pled guilty. And two, it's actually it's a violation of due process, because our process is an adversary system where you have two advocates. In a criminal case, it's the Department of Justice against the defendant. If an advocate lies down, for example, and doesn't argue, under that system of justice, it's over. The judge has no power. He's supposed to be passive. He's supposed to listen to two people arguing and then decide. The truth is supposed to emerge from that. So if one party doesn't say anything, then the other party prevails automatically.
In other words, we have to stop. But in other words, the prosecution stopped, or is the word rested? The prosecution said, we're not going to prosecute this anymore. And as you say, you need two to tango. You have to have a debate. So you have the defendant and you have the prosecution. The prosecution, which comes from the attorney general, said we stop. It should end.
It should end. Yes. I don't know of any other case where it's happened where parties withdrawn like that. I
don't know how he gets away with that. I don't know how he gets away with that. That seems like something that's got to go to the Supreme Court or something. It just seems very odd to me. It just 10 seconds, 5 seconds. I mean, doesn't that seem odd?
It's extremely odd.
How does he get away?
It's extraordinary, and in my view, it's an abuse of power by the judge.
Well, I think we learned a lot. I did. Yeah, it was awesome. Thank you, Mr. Wise. Thank you, everyone. It was so much fun.